Hi, good afternoon, and welcome to the first of a series of Justice Student Human Rights Network webinars. My name is Angela Patrick. I'm Justice's Director of Human Rights Policy, and I'll be taking you through this afternoon's talk. We've decided to have this series of webinars to help you, our student membership, get more in touch with the work that we do here at Justice. And we've chosen third-party interventions as our first talk because it's probably the area of our work that most of you would see as most closely related to your legal education and your training, working towards becoming a lawyer, working in practice. It is the one area of our work which sees us litigate, not on our own right, but as an interested third party seeking to put material before the courts in constitutionally significant cases, which we think will assist the court to make good law. So, by way of introduction, what we're hoping to do today is have me talk for around 15 minutes. You have some slides available on the site that you can look at your leisure. I'm not going to talk to them directly because that would be deeply boring, but I'm going to try and talk for around 15 to 20 minutes. I can see your questions as they come up. If I can, I'll answer them as we go. If I can't, I'll wait till the end and we'll have about 10-15 minutes thereafter for a Q&A or discussion if people are interested. So what we're going to do is say a little bit about what is a third-party intervention, how do you go about it in terms of both procedure and practice, and finally, we're going to look at a few changes to the law recently made in the Criminal Injustice in Courts Act, passed earlier this year, which Justice is concerned may make it more difficult for some interveners to intervene in some courts. So, what is an intervention? Now, traditionally in the UK, we're talking historically, any intervention was any attempt by any third party with a direct interest in a piece of litigation trying to get before the court. Now, in modern practice, under the civil procedure rules, look at Part 54 and Part 19, there's express provision for people who've got an interest but aren't one of the original parties to join a case, either as an interested party or as a party themselves after the litigation has started. That's not what an intervener is. It's extremely rare that an intervener, a third-party intervener, will be somebody who's got either a financial or other direct personal interest in the case. In most cases, an intervener is somebody, particularly somebody who's coming before the court as a public interest intervener, who seeks to come before the court because they have a particular interest in the law or the impact of the decision that the court is considering on the wider public interest. Now, this is a practice in the UK which is actually relatively new. Since around the 70s, the courts have been increasingly accepting applications by third parties to put public interest material before the court. Initially, this began with public bodies, most notably equality bodies, the predecessors of the Equality and Human Rights Commission, bringing claims where they had expertise, particularly on the anti-discrimination legislation, which was relatively new in the United Kingdom, which they sought to put before the court to help assist them make good law in the long run. It wasn't until the 90s when you got more cases coming from what are now commonly known as civil society organisations, organisations like Justice, who work in a particular field or with a particular part of the community and have expertise from which the court might benefit. Now, we call it third-party interventions here, but it's something that if you watch American courtroom dramas, you might be more familiar with. In America, there's no direct comparison, but they're routinely called amicus briefs. Amicus briefs in the UK serve a completely different purpose. They can be commissioned by the court directly. So please don't mix up the two terms if you're working in England, Wales, Scotland or Northern Ireland. Here, if you're a third party seeking to put material before the court, you're not an amicus, you're a third party intervener. Now, how do you do it? Well, as I said, different courts, different rules. The CPR did bring a direct recognition in our rules of court in England and Wales that provision should be made for a direct procedure to cover interventions. And you'll find that in part 54 of the CPR, which deals with judicial review. It is, for the most part, in judicial review cases where there are the most cause for interventions. In Scotland, they have their own particular procedures under the Rules of the Court of Session. You're looking at Rule 58. And again, different and distinct rules for the Supreme Court, looking at Rules 15 and 26. But justice doesn't limit our interventions to domestic courts. We often will seek where there are cases before the European Court of Human Rights which raise relevant points for the United Kingdom and the development of our law, take points straight to Strasbourg. And the Strasbourg Court makes particular provision for the acceptance of third-party submissions, and that's in Rule 44. Now, that's all very bland. I can give you the list and the rules. We could sit with the piece of paper and I could walk you through what each of the requirements for each of the sets of procedures are. They're broadly similar. And the one that we didn't mention was Part 52, which deals with the Court of Appeal. And interestingly, the Court of Appeal is one of the areas where there's very little guidance. There is no direct practice direction on how to proceed in bringing an application before the Court of Appeal to intervene in a case. But there's a long-standing practice which shows that the court will accept an ordinary application, either in writing or more commonly, more recently, by way of an ordinary application to the court, putting grounds before the court, expressing why you're an appropriate person to intervene, broadly what you say, and why you should be permitted to make submissions to the court. Now, of each of the rules, without going through them line by line, there are some common features which anybody who's considering a third-party intervention will be looking at. Well, first of all, why do you want to be an intervener? Why have you got something to say that the court should hear? And that's broadly identifying what you add to a case. What is the public interest in you being heard? The second is that in most cases, the court is looking for somebody coming before them in this capacity to be a reasonable person and somebody who is appropriate to put the particular materials they're suggesting would be of interest and assistance before them. So in that connection, Justice quite regularly in its submissions, making applications before the court, will set out our experience, how often we have intervened before the court and how regularly the court has found it helpful. We'll also specify, in connection with a particular area under consideration in the case, our substantive experience in that area of the law. But there's more to being reasonable than being the right person. There's being a reasonable actor. So, for example, complying with the particular rules of any individual court or the specific burden of an individual scope of the permission given by a court on an application to intervene is incredibly important. One example of this could be the length of the submissions that are placed before the court. For example, the rules of the Supreme Court are very definitive, and they say that they're looking for submissions in writing of around 20 pages. And the European Court of Human Rights is similarly prescriptive and suggests that you should only put 10 pages of submissions before the court. Now, there's a little bit of a question over exactly how far council may be willing to push their formatting, but generally the accepted practice is that you should have a reasonably sized font of around 12 points, and it should be a double-spaced submission. So in broad terms, aside from supporting authorities, the written material that any intervener is generally going to put before the court, unless granted special permission, is going to be of a reasonable size. Finally, there's a question of timing. If you want to intervene, when do you do it? Well, there's obviously tactical questions about which court you might wish to intervene in, how early you would go in. If a case is, for example, at a very early stage, it's being heard at, say, a tribunal or at the High Court, and the facts aren't yet determined. Is the material that you're going to put before the court relevant to the determination of the facts or relevant to the assessment of the law? Would it be better for you to wait and see if the issue is going to go to a higher court for determination, or better for you to get in early and try and help the court reach the right decision first time round? These are all decisions that putative interveners will be taking as they consider their strategy in any individual case. But that strategic conversation is on a timeline. You will have guidance from any individual court, either by practice or in the rules of court, on roughly how long you will have to consider before an intervention will be considered inappropriate. So in the Court of Appeal, it's generally understood that you should proceed promptly. As a good rule of thumb, it's good to follow the Supreme Court practice and never go beyond 6 weeks before the trial is set. That means if you are going to make an application, you should be looking to make one well outside that 6-week deadline. And the European Court of Human Rights, it's an interesting situation. You have 12 weeks from the point at which any case is communicated to the relevant state in question. This raises a number of issues, because obviously you have to be aware of the fact that the case has been communicated, or that deadline will pass reasonably quickly. There's a number of ways of doing this. Obviously, if you're strategically interested in a particular case for a particular reason, you may have been following it. You may have had it drawn to your attention by colleagues, but equally, if it's something that you are routinely interested in following the cases that are communicated to the United Kingdom, you can sign up for alerts on the Council of Europe Court of Human Rights, or the European Court of Human Rights website, and they will alert you to the cases that are communicated on a weekly basis. Now, what are some of the key issues? We're talking about strategy and people deciding how to proceed on a particular intervention. Well, you've got to decide what cases are important to you. Do you really want to pursue an intervention? The court, as I said, will only really entertain applications if they think it's reasonable and in the public interest to proceed. Otherwise, they might get to a stage where they're wasting their time looking at material that isn't really relevant to a case and isn't really going to help them determine the issues that are before them. So that's the first question that anybody who's ever contemplated taking an intervention must ask themselves. And it's a question that you must approach cautiously. Do I add value? What am I going to say? And will it be helpful? At Justice, we try to look at interventions only in those areas where we either have expertise by virtue of our previous work, or an issue is relevant to the work that we are currently conducting. And so we either have expertise in terms of research, or expertise in terms of our understanding of either the domestic legal position, or more likely our understanding of international legal frameworks, whether it's the international human rights law, the law of the European Court of Human Rights, or more broadly comparative experience from other European common law or Commonwealth countries. Now, in terms of the logistics, beyond the big questions of what will my intervention say, what do you physically have to think about before you proceed? Well, At Justice, we have lawyers in-house, but those of you who are long-standing members will know that there are not very many of us. So we rely very heavily on the assistance of pro bono partners. We're very lucky that we have a number of senior counsel and junior counsel, including mostly from a significant number from the Justice membership, who will offer their services to us in their areas of expertise for free. That's a particular consideration for civil society organisations like Justice, who are charities, or other not-for-profit organisations who have limited resources. Beyond that question of funding the case, in terms of who's going to do the work and how's it going to get before the court, the first question we often will ask is, shall we approach the parties to ask if they will consent to our application? Parties under any of the rules of any of the courts that we've discussed aren't required to provide their consent, but it is generally considered good practice to approach them and give the opportunity to either say, yes, we agree, you should come in, or to raise a particular objection about why they consider that your assistance is not required. It's then for you to proceed with your application to the court, setting all your grounds out, and asking them for permission either to make oral submissions or submissions in writing. Most broadly, most applications will include an application for submissions in writing. In some cases, there's a tactical question to be made about whether you can add anything by asking for some short period of time to make oral submissions to either clarify the submissions you're going to make in writing, or to give counsel an opportunity to respond to submissions made during the hearing by the parties. Now, these are all but a few of the practical considerations that come up during the management of third-party interventions. I'm going to leave you today with a list of the recent interventions by Justice. And you'll note there, for example, that a number of those are interventions we've done together with other organisations. Most recently, for example, I've led our case intervention in the Court of Appeal in the case of Belhadj and others versus Straw and others. That's an intervention which we're doing together with the International Commission of Jurists in Geneva, Amnesty International, and Redress. So there's particular interesting questions to be raised about joint interventions, about the management of shared work, about sharing expertise, and placing the relevant experience from each of the joint interveners before the court in a format that's digestible and agreed across all the institutions participating. But the most important issue, and the one that's been most recently highlighted in commentary as a result of the passage of the Criminal Justice and Courts Act and the recent reforms that the Lord Chancellor has made to the court's treatment of intervention in the Part 4 of that Act as a result of the government's Transforming Legal Aid programme, is the question of costs. Now, any litigant has to have at the forefront of his mind not only the question of how they pay for their representation, which we've talked about, but how they pay their court fees, which in some cases can be substantial. An application to the Supreme Court for an intervention is currently £800. But finally, whether they, by becoming a participant in the litigation, are likely to open themselves up to any prospect of a costs order being made against them by any of the parties already participating in the litigation. As you can imagine, if an intervener seeks to put material before the court, not in its own interest, but in the interest of helping the court better understand the wider implications of the case, it is arguable that it has limited financial benefit to that particular person. And particularly if those organisations who are proceeding are charities and not-for-profits, a risk that they might be subject to substantial costs could be a particular deterrent. That said, if interveners were willing to proceed in a way which was not reasonable, wasn't balanced, and was stepping into the shoes of one side or another, there is a question about whether or not they should be subject to some punitive costs regime. Now, the current practice is that in most courts, in the Court of Appeal and the High Court by practice, and as laid out in Rule 15 of the Supreme Court, the general practice is that if you intervene, you're granted permission in the public interest, and you provide material that is broadly framed to assist the court and within the bounds of your permission, there will generally be no costs order made in your favour. So even if you're helpful, you're not going to be rewarded for it. But equally, there'll be no costs order made against you. So that risk is not a significant one, as and until you act unreasonably. And in most cases, that's been limited to a limited number of circumstances, including where you take over a case and effectively run it as if you were one of the parties, or a party drops a point, for example, and then you run it in their stead. Now, we talked about coming back to the Criminal Justice and Courts Act 2015. Part 4 of that Act contained a number of controversial measures on which Justice is provided lengthy and detailed briefing. We're very concerned about the impact of Part 4 on not only the role of interveners, but on the legitimacy of judicial review, its accessibility, and its availability to individuals without means. Full justice briefing is available on the website, and I think there's a link available on the host site for today's webinar. But today we want to talk about the impact of the Act on interveners. What the Act does is it creates a new costs regime for interveners, where it effectively reverses the presumption that there will be no order for costs made against an intervener in certain circumstances. In 4 criteria, there will be, sorry, I've lost my notes. In 4 criteria, if 4 criteria apply, there's a duty now on the court to consider making, a duty now on the court to make a order for costs against an intervener. This is outlined in the slide, but they're broadly if the interveners acted in substance as the primary party in the case, if their evidence taken as a whole has not been as significant in assistance to the court, or if a significant part of the intervener's evidence and representations relates to matters that aren't before the court and aren't necessary for the court to resolve in order to resolve the issues at hand in the proceedings, or otherwise that the intervener has behaved unreasonably. Now, this is a step change in practice, potentially. It's the first time that interveners' costs have been dealt with in primary legislation, and it does create a new set of duties on the court to impose costs in particular circumstances. But there are a few things to note. The new rules only apply to cases that were brought after and lodged as judicial reviews after the 13th of April 2015. It won't apply to the Supreme Court, where Rule 15 will continue to apply, so there's a presumption that there will be no costs order made against the intervener. When will the criteria apply? Now that's the biggest question. This is a blank slate. We don't know yet how the courts are planning to approach each of the 4 criteria. Now, that is a good and a bad thing. It does mean that at present there's limited incentive for individuals who have limited means and organisations with limited resources necessarily to pursue an intervention, even if they think it would be helpful, as and until the cost situation is clear. However, we are at Justice and other organisations seeking clarity on how the criteria will apply in practice. And if you were working with an organisation themselves who were considering an intervention, it would be worth taking specialist advice. Now, even if the criteria will apply, it is worth remembering that there is an exceptional circumstances clause in the Act. So there will be, even if the criteria apply, no order where there are exceptional circumstances which will make it inappropriate for the court to make one. Now, that's section 87(7) of the Criminal Justice and Courts Act 2015. Now, there's a real question there, again, about certainty, because we don't know when the criteria will apply, how the court will exercise the discretion to determine the scope of those criteria, and finally, how the court will approach exceptional circumstances. So watch this space. The real question will be how, in the long term, these rules will affect interveners would-be interveners' relationship with the courts below the Supreme Court, and we'll really watch this space. In the slides, I've given you a list of a range of the types of cases in which only justice has been involved. I'm only going to talk to Justice's work today, but there's a whole range of organisations we've worked with and who continue to put material before the court, which the court finds of great assistance in a range of cases which are, in our view, constitutionally important. The range that we set out stretches from Binyam Mohammed and the treatment of secret evidence in Al-Rawi and Tariq, through to cases like Rabone, considering the scope of Article 2 and its application to patients admitted voluntarily to mental health institutions who subsequently commit suicide whilst under the care of NHS facilities. Stretching again to None, one of our most recent interventions, where we took material before the court to talk about the scope of access to material post-conviction for the purposes of pursuing a miscarriages of justice claim before the authorities in the United Kingdom. Now, the range of cases is obviously very wide, and the unifying factor is the public interest that Justice believes they were able to add to the case. Now, I've left you with a few quotes from the court's reaction to interveners. You've also got a link to Justice's briefing on the Criminal Justice and Courts Bill, where we deal at some length with how useful the courts have found the material provided by interveners over the years. I mean, CADA, which is one of our more prominent interventions, where we intervened in a case from Scotland at the Supreme Court about right of access to a lawyer and police interview, was helpful, described helpful by Baroness Hale. That might sound like a very short contribution, but it was indeed high praise. Lord Kerr, in a case called Ramatullah, very happily gave very lengthy judgment where we aren't mentioned, but his submissions are very close to those which Justice had argued in favour of, and he did speak very warmly extrajudicially about our contribution being powerful and significant. But that's enough about talking up our contribution to jurisprudence. What we have, I hope, given you today is a little bit of an insight into an area of law that's not necessarily familiar to you, but a piece of practice that as a junior practitioner you might find yourself being invited to become involved in, either as a paid advisor or as somebody invited by an organisation just like Justice to give us your time pro bono. Now, I'm going to wind up because I've now been speaking for 25 minutes and I haven't had any questions. I can see that there are a number of you that are watching. If you do have a question, please do let us know. If you want to ask us anything after the event, you can contact us directly through the Justice Student Human Rights Network forum on Facebook or through Twitter. I will be signing off very shortly, the next few minutes, if we don't have any questions imminently. And I'm just going to leave you with one last thing. That's the reminder that the application date for the current round of summer internship places at Justice closes tomorrow at noon. And if you are interested in that, please have a look at our website, where you can find all the details, what we need from you in time for tomorrow's closing deadline, and all the details of what life as an intern at Justice involves. Thanks very much for your time.